This one, I would like to quickly introduce this, and let me move over to this part of the stage. Section 1, it shall be unlawful for any person not being authorized by all the parties to any private communication or spoken word to tap any wire, cable, or by using any device. All the way, it talks about dictaphone, dictagraph, dictaphone, walkie-talkie, or tape recorder. Or, this is the italized portion, however otherwise described. This is the same ius dem generis rule that has been protecting us since 1965 because of the anti-wiretapping law. Because we could not predict all the forms of media for so long as it forms under this particular description, the anti-wiretapping law extends the protection to your civil liberties. It's not something different, not something strange, but the same ius dem generis rule. So far, so good? Okay. Section 5, other offenses. I personally and professionally don't know why this is being questioned. Aiding or abetting attempt. This is all over our statute books. In the Convention on Cybercrime, aiding, abetting, attempting is also a crime. This is equivalent to the frustrated attempted stage. This is equivalent to the accomplice accessory rule which we have in our statute books. Nothing strange with this. In fact, one penalty degree lower. So, nothing strange with this. We don't find anything particularly difficult to explain on this particular aspect. That's Section 5. This is now the trio of Section 5, 6, 7, which was accommodated in the BICAM, no? 5, 6, 7. Let's go to 6. Oh, I'm sorry. Can you read this? It says, all crimes defined and penalized by the revised penal code. This is the add-in provision, remember? Section 6, that all crimes in the revised penal code, if you put it online, is also a crime under the cybercrime law. This is what it is. And the 1 degree higher that is already being questioned. I'd like to bring this into 2 parts. I'll discuss this in the next slide, and then I'll talk about this in the next slide. There's another language course. It says, expressio unius et exclusio alterius. What does it mean? If I point to 5 of you, that excludes 95 of you. That's also a basic rule in law. So far, so good? Okay. The reason why this is in is because originally, in our technical working DOJ draft, we never went into enumerating specific content crafts. No libel, no cyber sex, none of that. We just want it content-related, which is something that we aspire for at international conventions. But as we go along, people tried to put cyber defamation, cyber threats, kept enumerating, until we got to the point when it said, if you keep enumerating all of this, it means that those that you did not enumerate under the revised penal code or the special penal laws is excluded from the Cybercrime Prevention Act. Correct? Which is not true. There is no enumeration of cyber threats. But you and I know, if I threaten you physically, or I threaten you email or text, those are crimes. There's no question of that. Now, if you don't have this provision, what happens? The defense lawyer will say, expressio unius, it's not in the law, therefore, it's not punishable. That was the problem we were faced when we were facing down to the last parts of the legislative proceeding. So we said, we might live with this better, quote-unquote, lesser evil, so we can fix it and explain it in the IRR that this is what it means. Remember, revised penal code plus special penal laws plus cybercrime law. The whole point of the cybercrime legislation was just to legislate on the 3rd block. But since Congress kept on picking out from the other blocks, we had to say, let's make it generic application so that there is no defense of, say, expressio unius as exterior exclusions. So far, so good? Okay. This revised 1 degree higher, don't be surprised. Actually, it starts with Section 4, but nobody is saying this. In child porn, it's only 1 degree higher. Okay? I will not belabor the point because we have differences of opinion. Some people will say 2 degrees higher. Some people will say death penalty. Some people will say decriminalize it. That's a legislative debate. Let the amendments take care of that. But this is not the first time you're seeing it. I just want to make a quick correction. In all the 15 petitions, they're saying that the penalty for libel now is 12 years, 10 years. No? That's an incorrect appreciation of the law. Presently, it's 6 months to 4 years. The correct reading is 4 years to 8 years. You may or may not agree with the penalty, I just want to correct an objective fact in the petitions. The fine is 600 to 2,000 pesos, or to 6,000 pesos. Not a lot of money, but of course you have your own different interpretation, which we will clarify in the IRR. So hopefully that takes care of sections 4, 5, and 6. What's after 6 is section? Liability under revised penal code under laws. Prosecution under this act shall be without prejudice to any liability for violation of any provision of the revised penal code or any other law. Question. What do you think of this? A lot of people are raising this section as a problem on double jeopardy. That you're punished online, you're also punished in the physical world. Anything wrong with this? Anyone? The basic question is, this is not section 7, it's section 17. This is not a typographical error, ladies and gentlemen, but I refer you to this one, which is now where this comes from. This is section 17 of RA 8484 of the Access Devices Regulation Act. It's been there since 1994. It's not first time we're seeing section 7 in the Cybercrime Prevention Act. It's always been our statute books. We've been using it. There have been a lot of Supreme Court decisions that have talked about other liability. The basic double jeopardy rule, we will never change. The Department of Justice will be the first one to say, it's double jeopardy, we will not do that. But if it's two separate acts committed in two separate worlds, you would be liable for two separate crimes. If it's just one act, punishable by two crimes, we have to pick which one is better, makes sense to prosecute. Okay? So this is section 17. Look at section 7 of the Cybercrime Prevention Act. I don't know if it's an act of fate, that 17 and 7, they're both 7. Lucky number for us. But if you looked at it, it's the same provision. Unless we're willing to invalidate all the other laws, we have it in the statute books ever since. Does it change the double jeopardy rule? No. You know, for all the difficulties we have in government, nobody wants to keep on filing cases. And if you keep on filing cases as a matter of use, that's a different story. It's a human factor, not a legal factor, not a policy factor, definitely not a technical question. So far, so good with section 7? Okay. And I just want to cite quickly, we invited a couple of media personnel, and I'm taking this quote from the blog of Raisa Robles, who I held in high esteem for her investigative journal. But let me just illustrate section 7 by this. She says in her blog, for instance, I told him, an interviewee, if a woman commits adultery using a computer, she would be guilty of a cybercrime, and her penalty would be 1 degree higher. This is the question on the 1 degree higher. Correct? Second, to use my previous example, referring to this one, of the case of the woman accused of adultery, because of section 6, if a married woman's email to her lover was submitted as evidence, the penalty becomes 1 degree higher. Pause for a minute, and with all due respect to Raisa, can you help me think of a scenario when adultery can be committed through the computer? I had a nightmare last night and said, how can I answer this provision? In what instance can I commit adultery over a computer? Seriously, I can't think of any situation where adultery can be committed with a computer maybe, but not through a computer. Okay? But the whole point is, we have to be very careful of this. I mean, as I said, I respect Raisa and all of that. But the question is, she might have been confusing the mode of proving adultery, electronic evidence, email, versus the fact of adultery. Two separate things. No two separate prosecutions. Definitely no higher cyber adultery. No higher cyber adultery. Definitely, I can say that. There is in law what we call factum probandum and factum prodans for the lawyers here. Two different things. Sounds like, looks similar, totally different. So with all due respect, let's be careful in blogging, because when layperson reads it, it creates another chilling effect or whatever it's called. Let's have a seasoned debate, a very clear debate on what it's all about. So far, so good? Good. Okay, now, this is the favorite part of our law enforcement and the nightmare of our telcos. It says, real-time collection of traffic data, the standard is due cost, does not require a warrant. Okay? It's not being questioned. Section 12. Now, what is collection of traffic data? I refer you to the definition. Traffic data means non